Adamson vs. Court of Appeals, 588 SCRA 27, Facts. On June 20, 1990, Lucas Adamson and AMC sold 131,897 common shares of stock in Adamson and Adamson, Incorporated, APAC Holding Limited. The shares were valued at 7,789,995.00 pesos. On June 22, 1990, 159,363.21 pesos was paid as capital gains tax for the transaction. On October 12, 1990, AMC sold to APAC Philippines, Incorporated another 229,870 common shares of stock in AI for 17,718,360.00 pesos. AMC paid the capital gains tax of 352,242.96 pesos. Commissioner issued a notice of taxpayer to AMC, Lucas G. Adamson and others, informing them of deficiencies on their payment of capital gains tax and VAT. The notice contained a schedule for preliminary conference. Commissioner filed with the DOJ her affidavit of complaint against AMC, Lucas G. Adamson and others for violation of Sections 45, A, and D, and 110, in relation to Section 100, as penalized under Section 255, and for violation of Section 253, in relation to Section 252, B, and D, of the NIRC. Lucas G. Adamson, Theris June D. Adamson and Sara S. de los Reyes were charged before the RTC Makati for criminal case. They filed a motion to dismiss or suspend the proceedings. They invoked the grounds that there was yet no final assessment of their tax liability, and there were still pending relevant Supreme Court and CTA cases. Initially, the trial court denied the motion. A motion for reconsideration was however filed, this time assailing the trial court's lack of jurisdiction over the nature of the subject cases. On August 8, 1994, the trial court granted the motion. It ruled that the complaints for tax evasion filed by the Commissioner should be regarded as a decision of the Commissioner regarding the tax liabilities of Lucas G. Adamson, Theris June D. Adamson and Sara S. de los Reyes, and appealable to the CTA. Commissioner filed a petition for review at the Court of Appeals assailing the trial court's dismissal of the criminal cases. She averred that it was not a condition prerequisite that a formal assessment should first be given to the private respondents before she may file the aforesaid criminal complaints against them. She argued that the criminal complaints for tax evasion may proceed independently from the assessment cases pending before the CTA. Court of Appeals reversed the trial court's decision and reinstated the criminal complaints. The appellate court held that, in a criminal prosecution for tax evasion, assessment of tax deficiency is not required because the offense of tax evasion is complete or consummated when the offender has knowingly and willfully filed a fraudulent return with intent to evade the tax. In parallel circumstances, the following events preceded Gr. Number 124557, on December 1, 1993, AMC, Lucas G. Adamson, Theris June D. Adamson and Sara S. de los Reyes filed a letter request for reinvestigation with the Commissioner of the Examiner's findings earlier issued by the BIR, which pointed out the tax deficiencies. On March 15, 1994, before the Commissioner could act on their letter request, AMC, Lucas G. Adamson, Theris June D. Adamson and Sara S. de los Reyes filed a petition for review with the CTA. They assailed the Commissioner's finding of tax evasion against them. The commissioning moved to dismiss the petition, on the ground that it was premature, as she had not yet issued a formal assessment of the tax liability of therein petitioners. CTA denied the motion to dismiss. It considered the criminal complaint filed by the Commissioner with the DOJ as an implied formal assessment, and the filing of the criminal informations with the RTC as a denial of petitioner's protest regarding the tax deficiency. Issue: whether or not the criminal case for tax evasion can proceed without an assessment. Held, yes. Citing SCRA vs. Pascar Realty, the court held that an assessment contains not only a computation of tax liabilities, but also a demand for payment within a prescribed period. It also signals the time when penalties and interests begin to accrue against the taxpayer. To enable the taxpayer to determine his remedies thereon, due process requires that it must be served on and received by the taxpayer. Accordingly, an affidavit, which was executed by revenue officers stating the tax liabilities of a taxpayer and attached to a criminal complaint for tax evasion, cannot be deemed an assessment that can be questioned before the Court of Tax Appeals. Neither the NERC nor the revenue regulations governing the protest of assessments provide a specific definition or form of an assessment. However, the NERC defines the specific functions and effects of an assessment. To consider the affidavit attached to the complaint as a proper assessment is to subvert the nature of an assessment and to set a bad precedent that will prejudice innocent taxpayers. True, as pointed out by the private respondents, an assessment informs the taxpayer that he or she has tax liabilities. But not all documents coming from the BIR containing a computation of the tax liability can be deemed assessments. To start with, an assessment must be sent to and received by a taxpayer, and must demand payment of the taxes described therein within a specific period. Thus, the NIRC imposes a 25% penalty, in addition to the tax due, in case the taxpayer fails to pay the deficiency tax within the time prescribed for its payment in the notice of assessment. Likewise, an interest of 20% per annum, or such higher rate as may be prescribed by rules and regulations, is to be collected from the date prescribed for its payment until the full payment. The issuance of an assessment is vital in determining the period of limitation regarding its proper issuance and the period within which to protest it. Section 203 of the NIRC provides that internal revenue taxes must be assessed within 3 years from the last day within which to file the return. Section 222, on the other hand, specifies a period of 10 years in case a fraudulent return with intent to evade was submitted or in case of failure to file a return. Also, Section 228 of the same law states that said assessment may be protested only within 30 days from receipt thereof. Necessarily, the taxpayer must be certain that a specific document constitutes an assessment. Otherwise, confusion would arise regarding the period within which to make an assessment or to protest the same, or whether interest and penalty may accrue thereon. Indeed, an assessment is deemed made only when the collector of internal revenue releases, mails or sends such notice to the taxpayer. In the present case, the revenue officer's affidavit merely contained a computation of respondent's tax liability. It did not state a demand or a period for payment. Worse, it was addressed to the Justice Secretary, not to the taxpayers. Private respondents maintain that the filing of a criminal complaint must be preceded by an assessment. This is incorrect, because Section 222 of the NIRC specifically states that in cases where a false or fraudulent return is submitted or in cases of failure to file a return such as this case, proceedings in court may be commenced without an assessment. Furthermore, Section 205 of the same code clearly mandates that the civil and criminal aspects of the case may be pursued simultaneously. In Ungab vs. Cassie, petitioner therein sought the dismissal of the criminal complaints for being premature, since his protest to the CTA had not yet been resolved. The court held that such protest could not stop or suspend the criminal action which was independent of the resolution of the protest in the CTA. This was because the Commissioner of Internal Revenue had, in such tax evasion cases, discretion on whether to issue an assessment or to file a criminal case against the taxpayer or to do both. Section 222 states that an assessment is not necessary before a criminal charge can be filed. This is the general rule. Private respondents failed to show that they are entitled to an exception. Moreover, the criminal charge need only be supported by a prima facie showing of failure to file a required return. This fact need not be proven by an assessment. The issuance of an assessment must be distinguished from the filing of a complaint. Before an assessment is issued, there is, by practice, a pre-assessment notice sent to the taxpayer. The taxpayer is then given a chance to submit position papers and documents to prove that the assessment is unwarranted. If the commissioner is unsatisfied, an assessment signed by him or her is then sent to the taxpayer informing the latter specifically and clearly that an assessment has been made against him or her. In contrast, the criminal charge need not go through all these. The criminal charge is filed directly with the judge. Thereafter, the taxpayer is notified that a criminal case had been filed against him, not that the commissioner has issued an assessment. It must be stressed that a criminal complaint is instituted not to demand payment, but to penalize the taxpayer for violation of the tax code. Section 269 of the NIRC, now Section 222 of the Tax Reform Act of 1997, provides exceptions as to period of limitation of assessment and collection of taxes. In the case of a false or fraudulent return with intent to evade tax or a failure to file a return, the tax may be assessed, or a proceeding in court after the collection of such tax may be begun without assessment, at any time within 10 years after the discovery of the falsity, fraud or omission, provided that in a fraud assessment which has become final and executory, the fact of fraud shall be judicially taken cognizance of in the civil or criminal action for collection thereof a broken bar. The law is clear. When fraudulent tax returns are involved as in the cases at bar, a proceeding in court after the collection of such tax may be begun without assessment. Here, the private respondents had already filed the capital gains tax return and the VAT returns, and paid the taxes they have declared due therefrom. Upon investigation of the examiners of the Burr, there was a preliminary finding of gross discrepancy in the computation of the capital gains taxes due from the sale of 2 lots of AI shares, first to APAC and then to APAC Philippines, Limited. The examiners also found that the VAT had not been paid for VAT-liable sale of services for the third and fourth quarters of 1990. Arguably, the gross disparity in the taxes due and the amounts actually declared by the private respondents constitutes badges of fraud. Thus, the applicability of UNGAD vs. SCRA is evident to the cases at bar. In this seminal case, this court ruled that there was no need for precise computation and formal assessment in order for criminal complaints to be filed against him. It quoted Merton's Law of Federal Income Taxation, Volume 10, an assessment of a deficiency is not necessary to a criminal prosecution for willful attempt to defeat and evade the income tax. A crime is complete when the violator has knowingly and willfully filed a fraudulent return, with intent to evade and defeat the tax. The perpetration of the crime is grounded upon knowledge on the part of the taxpayer that he has made an inaccurate return, and the government's failure to discover the error and promptly to assess has no connections with the commission of the crime. Issue 2. Whether the CTA has no jurisdiction to take cognizance of both the criminal and civil cases here at bar. Held, no, laws have expanded the jurisdiction of the CTA. However, they did not change the jurisdiction of the CTA to entertain an appeal only from a final decision or assessment of the commissioner, or in cases where the commissioner has not acted within the period prescribed by the NIRC. In the cases at bar, the commissioner has not issued an assessment of the tax liability of private respondents.